on our training session. It's a virtual session on environmental jurisdictions. As you may know, this training was organized within the framework of a project with the support of ELI, also Triple DI, and the General Prosecutor's Office of the Nation, and the Studies Institute of the Public Ministry. Before we start with the session, I'd like to remind us all that we have simultaneous interpretation. The Zoom platform will show you a button with the interpretation option. Please choose Spanish. The sessions are being recorded and we'll be sharing them with you later. Please be reminded as well to send your questions and concerns only through the chat windows, either Zoom or YouTube, and I'll be passing them on to speakers. As you may know as well, with the support of the Institute of Studies of the Public Ministry, we will be issuing a certificate of attendance to those of you who have attended the 4 sessions, but you need to record your attendance in the forms, the corresponding forms. We've noticed some interference when you want to record your attendance. So I'm going to make this announcement. Those of you who have attended the courses through YouTube and because of technical reasons, you've not been able to sign up and record your attendance, we'll be issuing a certificate of attendance. If you write an email to us today, explain the situation to us. Again, this is today, 5 p.m., the latest at this email that you see on the screen. I'll be repeating this information again. I'd also like to take advantage of this opportunity to present to you our website, the project's website. The ELI and GGI is a page that, as you may know, we are still developing. But the events section, this link, you will find this training. And we also have some other information related to these and other topics. In a few moments, I'll be sharing the link to that website as well, so you get to visit it and query in case you need information. Let's go over a little bit what we've done in the previous sessions. The first session, we analyzed in very general terms an overview presentations by Maris, Wright, Enders, Bengtson on the experiences there have been and the modes that have taken place, why these environmental courts have been created, and how justice has transformed in the environmental realm. Sessions 2 and 3, we looked at and we learned about different experiences from other countries about their environmental jurisdictions and their different instances. First of all, we heard the Vermont case in the US. We also heard about Hawaii and the Sudan case, the court in that country, and some references to other courts in other countries. This third session, we heard about some examples in Latin America, the Brazilian, Chilean, and Guatemalan experiences. All this has led us to today's session where we'll be analyzing, as a conclusion, some best practices and recommendations to keep in mind when you want to create a jurisdiction or this type of specialty towards the environment. This is today's agenda. First, a brief presentation, a recap. Then we'll hear Meredith Wright and Anders Bengtson with the effective practices and some ideas for environmental jurisdictions. Then there'll be a session on some perspective for Colombia and the convenience of creating this specialty in our country. This is by Gloria Amparo Rodriguez, JEP judge from, and also professor from Rosario University, and also Oscar Darío Amaya, a professor from Rosario University. I'm sorry, she corrected, Rosario University, and Oscar Darío Amaya from Externado from the State Council. We'll conclude with a Q&A session as usual, and finally, we'll hear some comments from Carolina Jaramillo from GGI and Carl Burke from Environmental Law Institute. The speakers, you've seen them, you've met them before, Meredith Wright, and our former judge, Anders Bengtson from Sweden. With us, we have Gloria Amparo as well. She's a winner of an international award because of her highlights and her work in peace building and environmental concerns. She's a researcher from the Jurisprudence Faculty of Rosario University. She's an attorney and has a specialty degree in Magisters of Environment and Development from National University. She has experience in environmental law, sanitary law, health law, negotiation, and conciliation, and she currently works as a magistrate for the JEP in Colombia. Oscar Dario Amaya is an attorney from External University, specialist in economic law from that same university. He has a PhD in law from Rosario University and Javeriana University and External University, where he does environmental law. He also studies postdoctoral studies from Zagorda University, who is founder and current professor of the environmental law group from External University. He has worked as a deputy minister of environment, delegated assistant procurador of environmental affairs. He's currently a council of the State Council. Thank you very much, everyone. We'll then start with the talk about general recommendations.
Good morning, everyone, and buenos dias. I, Anders Bengtsson and Meredith Wright will tell you a little about effective practices and some ideas on environmental jurisdictions. And I hope we can provide you with some of our experience today. Next picture, please. This slide is a picture that was developed by the late Professor Staffan Westerlund. His free filters. He was the first professor in environmental law in Sweden. He used to show this to describe the work to support a sustainable development in order to stimulate environmentally friendly behavior. You can reach far with moral, with your heart, with the information and education and social pressure. But to catch up with the behavior that slips through this filter, the next filter is economic instruments as penalties, fees, and also positive as subsidies. But you never can reach the goal only by such means, he meant, and then the ultimate filter is the law. How it's created, its interpretation and application and execution. And here the judiciary, the prosecutors, the courts and the judges has the vital function. Next picture, please. So the role of the courts and the judges is very important. That has been recognized during the last years by United Nations and other national and multilateral organizations. UN has developed much material available on the UNEP website and organized and supported numerous of conferences targeting environmental law and sometimes especially judges working in this field. Also in EU, the European Union, he has supported this by developing exchange programs where judges, especially working with environmental matters, have been provided visits in courts in other member states for 1 or 2 weeks to learn other systems. And since more than 10 years, EU also has provided seminars free of charge for judges and prosecutors in different member states on environmental topics. And there are also many networks for judges working with environmental matters, both regional and global. And at the bottom of this picture, you see an example from Brazil on water law, where many organizations were involved, and then there were developed statements for how to work with cases on water law, especially. So environmental law is comparably a rather new field of law. It's under constant development, and it's to a great extent influenced by international ideas and studies. So the legal landscape is moving constantly, and as a judge you must try to catch up with what is happening. It's not as in many of the civil disputes where you can rely on principle developed centuries ago. Here it's very modern and things are happening every day almost. So both with new the development of principles, and the case law is under constant development. So this puts the environmental judge in a special position, and the expectations are very high from the public, the state, and the industry and the parties. And one of the challenges is to balance the society's wish for development and the risks for environment and human health, and to this overriding goal of sustainable development. Next slide, please. But I think how, as a judge, how can you deal with this? I think it's very important still to guard the traditional requirements you have on a judge, or the ideal of a judge, that you keep up with ethics, and such topics ought to be discussed in a regular way. And the expectations from the public is to have a reliable judge, and you must have confidence in the judge. He or she must be independent, competent for the issues that are dealt with. The cases must be dealt with in an objective way, but also efficient. There is this old sentence, rights delayed is rights denied. So there is a balancing also between legal rights and the efficiency of the handling of the cases. And then the judge, he or she, what kind of person is it? Is it an activist, progressive, interested, engaged? So which impression do you give as a judge? And it's very important to think of this, not at least when it comes to environmental matters, because you can get a label that is make you appear to be non-objective, and that's not very good for the work and for the reputation of the court and the judge. So but still you must be interested in the issues that are at hand, and you can be progressive, and it's a little also depending on which kind of legal system you work in. In a system where you have a developed substantive law, it's you have easier to work within that field than if you only have to work with more overriding principles as the right to life. Then it's more easy for you or for the society to regard you as an activist. But maybe the result would be the same if you had the more developed rules to work with. So it's a little depending on which kind of system you work in. On the second session, I told you about that in Sweden we previously had these water courts that were from the beginning developed to facilitate for the industrialization of Sweden. And so they were actually what you could call exploitation courts. And when in 1999, when the environmental courts were created by the new environmental code, then there was a politically strong will to create a whole new court system because you thought there was an opinion that the walls of the water courts were contaminated by the old exploitation culture. But due to time restraints, there was no possibility to build a new system to employ new staff and move the archives and create a new administration, etc. But the new courts, they employed many new judges and technical judges. So there was a mix, and there also were a national program for education of all judges, but also all the authorities and politicians working in this field. So this apprehension of continuity of the previous image was stilled rather quickly, I think. Next slide, please. When the selection of judge working with environmental matters, I think it should not differ from the general requirements of any judge. But of course, it must be beneficial if you have experience and are interested in environmental law, and when you weigh what you have in your luggage, you will have an advantage, of course, if you have worked with environmental matters before. But also the working conditions in general should be similar to that of other judges, and when it comes to salaries and tenure, etc. And also when you think of the judicial career for a judge working in an environmental court, or what kind of solution that you choose in your country, the work must be inspiring for the judge. So it's rather important that the field that you're working in should not be too narrow. And with the experience from my country, I can say that you never be fully learned working with environmental law and also the planning and building laws. It's so much happening and so big areas and so many problems. You meet new ones every day, or even if you, after working for some times, you get acquainted with some of the issues, so it will the work will go more swiftly and efficient, of course. The training of judges is very important, especially when you start as a work, and especially then if you have limited or no experience of environmental law. So we have training both for new judges, but also continuity of the education. So we have, I think it's important to have workshops or seminars throughout the career, so you get updated. Some notes regarding pressure or threats to the judge in environmental cases. Well, my experience from working in a regional authority before I started in the court is that the position of a judge is much more protected from attempts to put pressure. But of course, it's different in different countries. And you may receive signals, for example, that the company is losing so and so many millions a day when the activity is stopped, and you are asked to prioritize that case. So this may happen, and it's not that seldom in our country that we get such signals. And of course that is okay, but so we can take such considerations when it comes to time, but of course not regarding the outcome of the case. That's quite a different point. And threats, I don't know of any such cases. We have the hearings can be very tough sometimes, and we actually have people was so affected that they actually died during the hearing. It's not often, luckily, but it happened because some of these disputes are very close to the people and the parties that are involved in the cases, especially property cases where there is an intrusion in your the property you own, and you're not allowed to take certain measures, or there will be a compulsory purchase for an area to build a road that will disrupt your environment that you may have had in your family for generations. But we sometimes get signals that there has been disputes between neighbors that has been very hard, also with shootings and so on. So then I have, but only once I've asked to have police protection when we should proceed an inspection at the site. And in that case, we actually got the neighbors to talk to one another and to agree on some steps to proceed voluntarily. So, but it's not often that we have to take such steps. But in all our courthouses now we have security control before entering the house, and but for the environmental court, most of our hearings are outside the courthouse. So, and there you will have the hearing in schoolhouses or anywhere, and then you must bring your own portable alarm system with us, and we always make some evaluation before we go out for an inspection or hearing, if there is any security problems, so we can provide for any steps to hinder that. Next slide. The jurisdiction of the court, you can take this from some different dimensions that is important to consider. First, you have, if you have decided on a certain model to specialize the treatment of the environmental cases, if you have an environmental court, a tribunal, if you will have green benches, etc., then in such solutions, you must have the adequate competence and staff and resources. And also you must consider whether you should have this specialization in the first level, if you shall have it also in appeals level or only in appeals level, and what to do with the final instance, the Supreme Court. So there is much to consider here. And then you also have the geographic dimension to gather cases, how to do this split of your country or your region in order to get a sufficient workload, and also that it shall be efficient and facilitate for the court and also for the parties. If you have this kind of traveling judges, and where you get out to meet the parties, especially if they are, you will have an inspection also, then you must go to the place. As simple as that. But then how to do this in an efficient way. And also you have to consider areas of legislation. Yeah, the first question is, what is environmental law? That definition is not always that easy, because almost any legislation has impact on the environment, but you must draw the line somewhere. And then which laws are beneficial to keep and handle together? That is a question to consider in order to enhance the competence and an efficient case management at the court. And as I said before, I think it's important not to keep the scope too narrow. As I mentioned before, the disputed provision or provisions in the legislation often has to put in a legal context in order to correctly interpret it and draw conclusion for the case at hand. You can, if you have a disputed provision in your legislation, you can't often not just pick that provision out and make an interpretation, because you must put it in the bigger context, and that's is a problem for, yes, in principle, all administrative law, that you can't pick up the disputed provision and make the right conclusions without having the broad picture. Yes, next picture, please.
Thank you, and good morning, everyone. We will be switching back and forth as speakers for this whole presentation. So for this slide, which presents a very difficult issue, I am only really able to raise the question and encourage that this issue is dealt with in whatever system is being set up. There are different initiatives worldwide to deal with the problem of threats to environmental defenders or parties and witnesses in general in the environmental litigation system. And we will post on the website the links to some of these initiatives. But these problems have to be seen not only as a problem for court, where you need to protect witnesses, but also as a human rights violation on the ground, that the available court mechanisms, for example, whistleblower statutes that protect people who are going to report problems from within an organization, and prosecution of witness intimidation are not necessarily effective outside of the court context. Some international treaties address this, especially the ones that deal with the public participation rights. And in fact, there was a recent decision by the commission that manages the Aarhus Convention to requiring the country, I think it was Belarus, to ensure that people are not penalized, persecuted, or harassed for their public participation. That was in the context of a demonstration, but we also have the problem of witnesses and parties being intimidated in their homes and even hurt or killed. And it is not clear that these are the methods that will be the most effective on the ground. So all I can really say on this topic is that people are working on different ways of addressing this, and that it is a serious issue in order to set up a system that promotes the rule of law. Next slide.
Yeah, now we're going to talk a little about dealing with expert and scientific evidence in our cases. Next, yeah, I can say that this is an excerpt from a painting of my court. The one with the measuring stick is the technical judge, and then you have the hedgehog, that is the legal judge, the law-trained judge, and you also have two specially appointed members and a secretary at the inspection. Next slide, please. Well, if we start with the administrative cases, and then of course, depending on how your system is built, there can be a very heavy burden on the court to investigate and interpret the technical and scientific evidence, and also how you place the burden of proof will have a great importance here. So one crucial question is, how deep must the judge have to analyze these issues? And that makes then the pressure on the court to provide for how to solve this problem. If you have a very high burden on the judge to go into these issues, then he or she must have some kind of help, because most of the judges are only have legal exams, not technical or other scientific exams, but it may occur, of course. But the situation is a little different in criminal cases and civil cases. But I think if we start with the criminal cases, even here it's important to understand that environmental crime, it's a form of economic crime, or at least the absolute majority of the environmental crimes have economic motives, and then I can draw some conclusions from experience in my country. The legislation may have gaps, and then the principle of legality prevails, if there are high pressure on the court to convict a person. But nulla poena sine lege, so the legality principle is very important to have in mind also in these cases. But sometimes when you have a provision, it can be related to, for example, risk to health or environment, and the risk over a certain threshold. And the burden to show these risks lies in the first hand on the prosecutor, but the judge must also have a general knowledge and understanding, or at least an ability and a will to understand complicated issues regarding such questions. And to understand, is there, for example, a high risk for a huge negative effect, or do you consider that the risks are low and the effects negligible? For example, in some exploitation measures in an area with a habitat for endangered species, and the risk is high for decrease or even extinction of extermination of a population of endangered species. And are these issues clear for the judge? So this is legal questions, but where the threshold lies. But it also depends on your understanding of technical and scientific matters and how it is presented for the court. And the burden on the prosecutor is to convince the court this is high and very important. But of course, also the judge has his or her own responsibility. And the knowledge of overriding principles, for example, the principle of preventive actions and the precautionary principle, may also have an importance to determine the intent or negligence of the defendant. And it's also important, once the judges have established that there has been committed a crime and the sentence shall be decided, and to put this in relation to the gravity of the offense. And the gravity often you can find in the science and the technical matters. And one problem is, for example, in my country, at least the lower courts, the understanding of environmental law is rather low, and there are very few cases. For example, the majority of district courts receive only around one case a year, and most courts then have 8 to 10 judges. So each judge gets a very few such cases during his or her whole career. In criminal cases, in my country, we don't have technical judges involved, but of course, here as well, in all cases, the parties may refer to external experts. And some words about civil cases. Before opening a civil case, there may have been a procedure to mediate, but otherwise the first instance is the court. And in environmental cases, there may be some special rules, for example, on least burden for the causal link, and there can be provisions on strict responsibility. But anyhow, in civil disputes, the questions can be very complicated, and the technical and scientific documentation of surveys, reports, and analysis on chemical substances, for example, can be very heavy. And we find it then very beneficial for us to leave the technical issues in the first hand to the technical judge. But and the law-trained judge in its turn will in the first hand concentrate on legal issues, but both the legal or law-trained judge and the technical judge have a responsibility for the whole case, and also must try to understand and take standing regarding each other's areas. And in civil cases, one issue that should be mentioned is that the strengths and the resources between the parties can be huge, and in some systems there is provisions that can make the judge to take into consideration such issues when preparing the case, but that's not always the matter. And also in appellate courts, you may need access to scientific and technical expertise to fully understand the issues so that they can make good judicial decisions. And here you have different solutions in order to get help for the law-trained judges. And that is, you can have internal experts, as I mentioned, our technical judges. And in my country, though, the technical judges are employed, so they have a permanent position at the court, and they are involved in principle during the whole preparation of the case until the judgment is signed by them as well. And they are voting if necessary, etc. On the other hand, we have also what we call specially appointed members that are involved once we have decided when to have a hearing, so they come in rather late in the case. And then in advance of a presentation of the case for a panel of the judge, the technical judge, and the specially appointed members, or in advance of a hearing, we send out all the relevant documents to these specially appointed members so that they will be well prepared for the proceeding. And the technical judge have an academic degree in technical scientific areas, and even if, for example, we in my court have 11 of these technical judges, they are more generalists, and only in some cases they can be said to be specialists because there are so many areas to cover. The specially appointed members, we don't have these formal requirements of academic degree, but they can have, and they also have a long experience from working in relevant sectors. But this is one way to solve the problem. Otherwise, you can have expert panels and experts appointed by the courts. We have special commissions, as I mentioned in the case of Netherlands, where the administrative court can refer the case to a panel or an independent authority with experts employed that free of charge make an opinion that are sent to the court, and then the court takes its decision, taking into consideration what that authority has said, but they are not bound by it. And there are other solutions in order to get external help, for example, by the academia or governmental authorities, etc. Next slide, please.
In these two slides, I'm going to present to you a process that has been developed and is being used very successfully in the Australian state of New South Wales, which has a very robust environmental court called the Land and Environment Court of New South Wales. In this process, which was first developed by the court as a special rule in the court and has now been adopted as an overall rule for their procedures, the experts who are in general in their system or in most common law systems or Anglo-American systems, the main source of expert and scientific testimony are the experts called by the parties as witnesses. But these are highly trained people and who have, there's always the problem of when the experts are presented by the parties of when they're paid by the parties of having them presenting the best take on the science or the technical issues for the party which has called them. And this procedure enables the system to narrow the areas of disagreement among the experts and allow a full exploration of the areas in which scientific or technical experts might disagree in a case. The first thing that is required, and so in this process, the experts will actually collaborate with each other and give evidence together. So the first thing that is required is that the experts prepare their own written reports about the subject of the case. But then they have a conference together, the experts without the lawyers for the parties, and they are expected to engage in a full and frank discussion to determine the areas, the matters on which they agree and on which they disagree. And in many scientific disciplines, there is a very wide area of agreement and a very relatively small area of disagreement, which may not have to do with the underlying science or technical testimony, but only on how it should be applied to or interpreted in the particular case. So they are working on in their technical capacities and without the influence of the lawyers for the parties in determining the areas of disagreement and agreement. Next slide. This conference then produces a joint report explaining to the court what the areas of agreement and disagreement are. And this helps enormously in narrowing the issues that are actually in dispute during the case or during the trial. The experts on a particular subject, and in many of these environmental cases, there are many different areas of subject matter areas that have technical or scientific evidence. So it would be the experts on each of these topics, for instance, the groundwater experts or the erosion control experts or the forestry experts will give evidence together rather than the former method would be to have each expert presenting his or her own evidence in the case presented by one or the other party. So they give their evidence together and they're able to explain the issues in their own words rather than simply only answering questions from the lawyers and commenting. They can comment on or question the other experts back and forth. And only after all of that has occurred may the lawyers, or in your system, the court, question the experts, and then the parties can rely on their own experts to clarify and answer. This procedure, while it was resisted by many of the lawyers who were certainly not used to something as collaborative as this, has been very well accepted over, I think it's probably been in use for about 15 or 20 years, and has now come to be the method that is used for most expert presentations or science or technical presentations. Next slide. We will now turn to the question of judicial orders. That is, what can the court order in resolving or managing a case as it goes through the environmental system. Any system that is set up that involves environmental problems or environmental enforcement must ideally provide for all of these measures. These measures are not necessarily all provided in an environmental court, depending upon how the specialization is set up. For example, both in Sweden and in Vermont, the criminal cases go to the regular criminal courts, where in Hawaii and in New South Wales, the criminal environmental cases are handled by the environmental court. So first, it is necessary to have some way of issuing and enforcing preventative measures before the case has completely gone through the court system. So at the very outset, or sometimes right before the case is filed, or as the case is being filed, the parties will request some urgent preventative order. And for example, don't cut down the trees until the case is resolved. And there are a number of ways in which this is authorized in the various legal systems, but it is essential to have preventative measures that the judge can take, not only at the end of a case. China has been struggling with this because in their system, at least until quite recently, you could not file a case until the damage had already occurred, because you had to allege the damage in the documents that start the case. And that made it, or makes it, difficult to stop work or to stop an environmental harm from occurring while you are determining whether it is illegal and whether it should be stopped. Another large aspect of the menu, or arsenal, if you will, of judicial orders are monetary penalties. And I urge you not to think of these only as fines in the criminal system, because one of the most powerful aspects of monetary penalties in an environmental enforcement system are penalties that are keyed to the economic benefit or the profit that is received by the violator from doing the illegal activities. As Judge Benson said earlier, most of these cases have some economic element. And unless the monetary penalty can account for this element and remove it from the defendant or from the violator in the process of the court, there will be no incentive to stop the activity, but rather what happens is people accept, especially large actors, accept that there will be some amount of fines and treat it as a cost of doing business and continue to do the violations. So there has to be proportionality, but the proportionality can be looked at with these monetary penalties, which in our system are in the administrative and civil area rather than as criminal fines, is to make them proportional to the economic benefit or to remove the economic benefit before considering the other factors that might go into a penalty. A third area, of course, that is important and is in most systems, whether it is in an environmental court or the general criminal courts, is the availability of imprisonment as a sanction. The problem with this is that corporations cannot be imprisoned, and it is sometimes difficult to find the actor within an organization who should be treated as the acting defendant and who might be subject to imprisonment. But it is possible and is done in, I think, in the US federal system at least, to put a corporate defendant in a criminal case on probation, even though the corporation cannot be imprisoned itself, but to have a series of requirements which, if they are obeyed, then protect the individual or protect the organization from further sanctions. A fourth area that needs to be provided for in whatever system of environmental adjudication is set up is the availability of money compensation for harm, for not only environmental harm, but harm to human health, harm to communities from environmental violations. And this is generally done through the civil law, but there's one area that I wanted to emphasize or raise with you, and that is the idea of compensation to the state for damage to natural resources, which are not privately owned, but which are the really the patrimony of the nation. And there are, of course, difficulties in determining these amounts, but it can be done and has been done in some of the biggest cases and should be considered to have this ability in any system that is created. And finally, but by no means the least important, but possibly the most important, is to have the ability to impose, and we will talk about in a little while, the ability to enforce orders that require corrective action or restorative action, remedial action by the defendant. These orders, and this is where it may be important to distinguish between, in the administrative arena, between sending a case back to an administrative authority for the authority to change or impose an order as compared with when a court can impose an order requiring restorative action. One of the other problems with simple monetary fines, especially in the criminal context, is that the money goes to the Treasury in general and is not used, or not, it is not often set up to be earmarked for taking on remedial or corrective work, even when it is the violator who is paying that money. So having the ability in the system to require that the work be done is an important element. Next slide.
Yes, I will take up some special forms that we can be interesting in this when we talk about these issues, and there's that with such measures that I have some experience of in my country. And this is, the first one is summary imposition of fines that we call when the prosecutor has a possibility to issue or impose fines for minor offenses, where the punishment only covers fines or conditional sentences. And this summary imposition of fines, I think they can go up to around $300,000. And if it's admitted and signed or paid the cost, the fines have the same impact as a judgment from the court, and is registered in the criminal records. And then the next one is corporate fines. That is a rather new issue that we have, and that is giving the possibility to impose a fine on the company without pointing out a certain person within this legal person that should be responsible for the offense. And this can also be combined when it's more major cases, or the offense has been made deliberately. Then the corporate fine can be combined with the punishment for the individual as well. And these corporate fines, they can be imposed by the prosecutor, but also by the court. To distinguish this from the summary imposition of fine, there is no registration in the criminal records for this, because there is no individual that is targeted. The maximum of these fines this year raised from 6 to 50 million US dollars. The minimum sum for these fines is $500. Then the next one I want to highlight is a ban from commercial activity. That is to restrict or stop commercial activities that are regarded as unreliable. And this is personal, and often, for example, the general manager of a company can get this ban if convicted for economic crime. And as we have said repeatedly, that in principle all environmental crime has economic motives. And the prosecutor then claims for the court to decide on a ban from commercial activity, and such a ban can last for between 3 and 10 years. And not to respect such a decision is a criminal offense itself. And then I will add to what Judge Wright has said regarding administrative sanction fees. We have a system where the supervisory authority can impose such fees for minor offenses. But there is restrictions that you are not allowed to prosecute twice for the same offense. So if the person already have been prosecuted in an ordinary criminal proceedings, then it's not possible to impose an administrative sanction fees, and the same goes the other way around as well. Thank you. Next slide.
One of the most difficult areas in looking at the court's authority to issue orders and its powers has to do with how those orders are actually implemented, how they are enforced so that they are actually carried out. Throughout the world, there are some wonderful examples of very detailed and far-reaching environmental cases with court orders that require important action. But if you actually look at the aftermath of those cases, you do not always see that these orders have actually been carried out and have actually happened in real life. So I would like to outline a few methods which are in use for assisting the court to see that its orders are carried out. First of all, there is a power inherent in courts, and this has been explored in the jurisprudence of at least the common law countries, and I am not familiar with the jurisprudence on this point in the civil law countries, but it is considered that there is an inherent power in the court to see that its orders are obeyed, that its orders are carried out, because without that inherent power, there would be no rule of law. And there are proceedings within the court in these countries, loosely called contempt proceedings, where the judge or the court can even though the case may be over, can have the party come back into court for an order to, and it's called to show cause why it should not be held in contempt for failing to carry out the order. Sometimes the result of such a proceeding is a change in the order because there was something about the order that made it difficult or impossible to be obeyed by the defendant. But the court does have powers to actually impose fines or sanctions or even criminal sanctions against a party that is completely disobeying a court order. But issuing a further order is not always successful without a method of enforcement. And possibly in the questions section, Judge Bengtsson can talk a bit about the Swedish authority that carries out some of the administrative orders. Another method is for the court to appoint a third party unrelated to the case to carry out the order. And in these kinds of instances, it is then necessary to provide for payment of the expenses of this third party. Usually that is done through a order attaching the property or the funds of some assets of the defendant to make sure that there are funds available for carrying out the order. Another method, and this is effective especially in regulatory systems where the posting of a bond or a letter of credit can be required as a condition of a permit or license to operate, so that this ensures that there are funds available. For example, in a mining license where the environment is supposed to be restored at the conclusion of the extraction, having the business post a bond or a letter of credit which is intended to be used if necessary to carry out the remedial work on the site, that if that is posted as a precondition of starting the work on the site, then you have a much better ability to enforce the requirements. I mentioned attachment. This is an order that puts a hold or a lien on a bank account or on property to ensure the payment of either the fine or the remedial work once the case is over. There can also be limitations placed on the resale of private property, which is very effective to avoid especially in development, land development projects, where once the company has developed its, let's say, housing development and sold all the houses, that then there are no assets to ensure the enforcement of the court order. So placing a hold on the sale of the property can be very effective in such a system. Judge Bankston already talked about limitations on conducting business, and the last thing I want to raise in the area of enforcement of court orders is the existence or creation of a trust fund managed by an independent trustee to dispense the money needed to carry out an order over long term. The Deepwater Horizon case in the US, which is a massive case involving the consequences of oil spill in the Gulf of Mexico, has set up a trust fund with the large amounts of money resulting from the conclusion of that case, and it is administered and dispersed in order to do the remedial work, which is going to be ongoing for a long, long time. Another way that trust funds can be used is to create a fund independent of a particular case, such as what's colloquially called the Superfund in the United States for the cleanup of hazardous waste sites, or also in the US, the Petroleum Oil Pollution Cleanup Fund, which are funded not only by fines and penalties from cases, but also funded through a tax on gasoline and oil products, so that there are funds available to carry out or reimburse the cleanup, even if a defendant is unable to accomplish the cleanup with its own funds. Next slide. We are running a little behind time, so I'm going to go very quickly through this because we addressed it in the first session. And that is just to emphasize that in designing a system, you have to think about a number of access to justice issues. One is, what rules are you going to have to allow people to bring cases or to participate in cases that are brought by other parties? Another element is the placement, as we've both discussed in talking about our own courts, is the placement of the courts so that they are, or the hearings, so that they are accessible to not only the big actors, but the local people who need to, or who might be unable to either attend court or undertake the expense of travel. So that, and this can be done by having courts that operate in different places, or by having courts or judges who travel to different places close to the area that the case arises and hold the hearing in a facility near that location. The New South Wales court even actually holds outdoor hearings at the location of the site visits. So those are considerations. The financial accessibility, whether people have to pay a filing fee, whether they have to pay for their own experts and things like that, can be adjusted in an appropriate system. And finally, what I'm calling linguistic or cultural accessibility, making sure that the information about participating in and filing cases is available in all of the local languages, and is presented in such a way that it is takes account of the cultural needs of the population that it's serving. Next slide. I'm going to just talk briefly about the importance of making available the decisions of these courts, making them available to the public, not only to the parties in the cases, and to the extent possible, ensuring that they are reasoned decisions that lay out the reasoning for the decision in the case. There is some amount of mythology that this is only something that is important in common law countries because cases can have precedent. But in fact, this is not an issue to do with precedent. This is an issue really to do with transparency. It supports the rule of law in ensuring that the population generally understands, or has the ability to understand, that cases are being decided impartially and according to law. It is also, there is a saying quoted by a United States Supreme Court justice in the previous century, that sunshine is the best disinfectant. And this is the idea that when you make decisions or actions publicly known and available to everyone, that there is much less opportunity for unfair influence. It is also, I think, important because well-reasoned decisions provide persuasive reasoning in other cases. And this is as true in civil law cases as systems as it is in common law systems. If you think of these decisions as if they were little chapters in treatises on environmental law, you can think of it that way rather than as they're not precedential in any way. But it creates greater public acceptance of the outcomes of these decisions, and it also allows for greater public oversight or monitoring of how the decisions are actually carried out in the real world. Next slide.
Yes, a few words on alternative dispute resolution. This kind of alternative way to resolve a case can often be both cheaper and faster than to resolve it in a court, in the ordinary process. And especially when it comes to parties that have some kind of relation, for example, neighbors that shall live close to each other also in the future. They are dependent on a functioning daily life, even if they really not always understand that themselves. Some lives for the disputes, unfortunately. But in general, it's more easy than to convince them that a settlement is to prefer instead of having the court to decide, so at least one of the parties will be dissatisfied. Often both of the parties will be dissatisfied, and that is the best solution. Often the dispute is based on something historical mistake, or sometimes it's impossible to mediate. And you can find, especially in land disputes, that the dispute is actually inherited from the ancestors. It can go on for ages and for generations. In civil cases, it's obligatory in many countries, either before you go to court or during the proceedings at the court. And then you can have mediation or conciliation, negotiation run by a judge or any other external person, or a judge at another court. So in civil cases, it's more institutionalized. In administrative cases, at least in my country, we have difficulties because it's not provided for. But when we have disputes between neighbors and there is limited public interests or interests of third parties, then we can make some negotiations and try to get them to the neighbors or the appellant and the authority to make some kind of agreement. If we have a mediator within the court, and then the judge that have tried to mediate, or we have a technical judge, and if it's not succeeded, then in many cases we need to hand it over to another court, judge in the court that has not been involved in these discussions. Next slide, please.
And finally, and because we have overspent our time by about 5 minutes, I will not spend very much time on this final slide. But in designing a system, I just wanted to remind people that although this area of court management is generally accomplished by internal court rules rather than by new statutes, that there are many, many innovative methods that can be applied in case management to make these cases move forward efficiently and effectively. I have listed a few of them here, especially the first two result in scheduling orders or the movement in a case forward, tailored to the needs of that particular case, so that certain legal questions might be decided first before certain scientific investigations take place, and whatever that particular case requires can be, if the court holds pretrial conferences and issues scheduling orders, it can be tailored to the needs of that case. Ordinary court clerks in the regular court systems tend to think that this is catering to the, or coddling the parties, but in fact, it turns out to be very efficient and to avoid problems where people are spending resources unnecessarily. Next, there can be submissions requested by the judge or requested to be submitted by parties who are not in the case, but who may have, we have had some cases in the United States where a group of law professors get together and submit a friend of the court brief to illuminate a legal question that is at issue in the case. And then finally, and this is really an enforcement of judicial orders issue, it is sometimes very effective to hold telephone conferences with the parties after the decision, for them simply to report back to the court on how the orders are carried out. This is not necessarily something where the court has additional powers, or even whether the case is still open, but it does have a very salutary effect on, especially in the smaller cases involving smaller parties, to make sure that they actually do what they have said they will do. And so I will say gracias on behalf of both of us, and we will look forward to the following presentations and be here for questions at the end.
Thank you, Meredith and Anders, for your presentation to review and summarize some of the most important topics that we had analyzed in the first 3 sessions. Now I pass on the floor to Gloria Amparo Rodriguez, professor from Rosario University and a magist from JEP. Good morning, and thank you for the invitation. I'd like to point out that this event has received the best comments, the best assessment. This means that we have reached a big record and see what we're going to do from now on environmental issues in Colombia. Of course, all the light that has been shed, and thank you, the previous speakers, especially Anders and Meredith. They've given us very important elements to move on. I'd like to start with my presentation now, and I'd like to highlight, first of all, that I thank your invitation, and especially highlight that the question that I've been asked is whether we require an environmental court in Colombia. Do we need an environmental court in Colombia? What is happening with this here in Colombia? And if it is necessary that we move on towards this specialized court. I could start by highlighting that here in Colombia, in the last few years, there's been an escalation, very important escalation of environmental conflicts. Those environmental conflicts that relate to the social conflicts as well, that take from different topics with different stakeholders, of course. public stakeholders, private stakeholders, local, national, and even international stakeholders, because many of these environmental conflicts have reached international opinion. We've seen they've arisen because of different interests, surrounding interests as to how we're going to manage, how we're going to use, how we're going to exploit or benefit from certain natural resources. In the last years, we've seen an increase in the number of conflicts, how every day we hear more and more about greater sue, suing processes, proceedings, greater number of legal processes that have to do with this topic. So we find that we have we've seen an increase of the number of environmental conflicts, and we see that judges and lawyers running to sort out issues that have to do with social issues, cultural issues, economic issues, political issues, and also with ecological issues. Those topics that judges have had to face, of course, have a very close relation to natural resources, with how the natural resources are being used, how in addition to this here in Colombia, they're using infrastructure work. So we find multiple cases where they talk about, for example, infrastructure with big conflicts. For example, of Urra, it's a case after 20 years after a very important sentence of the Constitutional Court. We can say that it's one of the big environmental conflicts that we see and we continue to see in our country. Nevertheless, the decision of the judges, it's been difficult to sort out these conflicts. We see that judges have to face issues in mining, hydrocarbons. We see that judges have to hear environmental cases, very complex, for example, pollution, pollution of land, air, pollution, a also electromagnetic things, tourism. And we all here, we see judges that they have to develop knowledge on topics that refer to activities, let's say legally or illegally, about exploitation of resources. And here we see cases that are very difficult. For example, environmental licenses that have been granted. Many times we see that there hasn't been prior consultation or previous consultation, environmental impact assessment studies that should have been carried out before the licenses were issued. And so authorities that have attended or have resource to other mechanisms find judges the way to sort out those conflicts. And of course, we also find illegal activities such as illegal mining, illegal exploitation of natural resources for resources that has led to generate important space so that judges can intervene. So during this judicialization of environmental conflicts, we find expert judges who specialize in legal objects, but they are facing technical issues or about other areas such as economy that imply big challenges, huge challenges, of course, for themselves and for our country. From that viewpoint, like to highlight some figures that caught my attention. And why do I say that the environmental conflicts in Colombia are being judicialized? These figures from the Constitutional Court highlight, for example, that between 1992 and 2019, in the Constitutional Court, they've seen about 7,774,060 actions of law. And between January and November 2019, we heard about 662,709 actions of law, out of which many of them had to do with topics related to environmental topics. For example, the right to water, drinkable water, access to drinkable water, 1,048 cases. Also about environmental issues, healthy environment, 140, previous consultation, 143, many of which had to do with environmental issues as well. And things such as participation in environmental issues directly in participation, that was 28. These figures are very interesting because we find a constitutional court or a constitutional judge dealing with environmental issues. And this had to do with technical issues, for example, to sort out issues of water pollution.
Something needs to be pointed out. The Rosario University group had some work about this, and we found the number of popular actions per each right, and it shows that the environmental protection in Colombia is constituted in a very important right. Why is this? Well, you can see that this chart that is presented by the group establishes that 17% of those actions are related to environmental issues. Public health, here we have percentages, utilities, 13%. That means that judges also play a very important role in solving those environmental conflicts. Let's look now at integrality and defense of collective rights. One of the main of the rights that are there, the first one is to have a healthy environment, according to Rosario University by Beatriz Londoño. She led the program. Many of these rights are there. Then the second one is existence of ecological balance. We're talking about topics that are very, very important topics related to environmental issues. And that means that judges also need to handle many of these topics as well. Could you please make them bigger, the slides, so that we can see them better? Oh, is it better? Yes, perfect, thank you. All right, so as you can see, we're talking about many cases that are related to environmental topics at the state council level. Now, let's look at administrative judges. First, enjoying a healthy environment. That's the first one that you can see there. Also, having public space, number 4, ecological balance, number 3. So one can say here, so we have public health and safety, number 7. So this study conducted by Rosario University, why is it that we required, I mean, if you keep this in mind, is it required or isn't it required to have a judge with expertise in environmental matters? I just want to bring you some examples. With all the good willingness from judges in the Urra case, one can say that after so many months, years that pass, look at the communities and what happens there. Also, some experts have called it train crashes because of the Wuwa indigenous people. Look at also fumigation. A judge, in his decision, he says, evidence in the file does not suspect, that make one suspend imminence of transgression of environmental rights. It was not demonstrated that omissions cause environmental damage and health damage. This is what the judge says in his ruling. So this is very related to precaution principle. This is an environmental topic. This is something very transcendent, and it means that judges need to start thinking about this. And a second step, which is related to electromagnetic pollution at an electric substation. They say the precaution principle does not apply. And he says that when establishing the need of protecting a healthy environment in the face of threats, they have not been scientifically proven. There is possible occurrence of serious damage, and there is no scientific evidence to apply this principle, precaution principle. So what is the interpretation the judge is giving to this precaution principle in environmental issues? What I would like to point out is what is happening with these types of rulings. And I would also like to talk about the last 14 decisions, rulings from different operators, let's say. I'm talking about the Constitutional Court, Supreme Court, also municipal judges. We have 14 rulings that are related to nature as the subject of rights. We have ruling from Atrato River, the Amazon area, Pisba. We have Coello River, La Plata River. We have Cauca River. Can you imagine this trial talking about something that involves the whole country? Pans de River, Otun, Magdalena River, a judge speaking about Magdalena River and speaking about the river as subject of rights. One judge there in Neiva, Quindío River, Salamanca Park, bees, the topic about bees, Clifford, yeah, mascot, the Clifford, right. In Ibagué, he speaks about fundamental of for this pet. You know, it was Clifford, that pet. He speaks about that. His rulings about that. So the importance of having elements to this. What do these rulings imply? It is very common for judges to produce rulings. We see them in the news. And when you actually go and look into them, what are the arguments they have to determine these types of decisions, rulings? Scope and contents of these types of decisions imply a big risk. Therefore, specialization is important. Then, since 2013, the national government, through the minister, Estela Correa, mentioned that it was necessary to have specialized judges in environmental issues. And she said, why? Very complex cases have to be solved. It is necessary to have correct decisions, and this implies having a jurisdiction with administrative judges in environmental issues, and from there on to start talking about this. They said, the national government, that beyond difficulties that are common to all justice administrations, such as, you know, very crowded courts, excessive, long, you know, prolonged processes, and not enough resources, financial resources, an administrative judge faces an environmental case, they need to face additional difficulties. Therefore, their specialization on these issues is necessary. This is what was said back then, the minister in 2013, the national government. And we have heard also Fernando Carrillo also mentioned Colombia needs to create environmental jurisdiction. We cannot delay this step anymore. So this implies having this discussion about this, and they are telling us about concrete cases. In Colombia, there's a great difficulty because of illegal mining, deforestation. It talks about water quality, air quality, etc. And Fernando Carrillo says, the environmental court is necessary. We do need it. The environmental court or a scenario for a specialization in environmental issues. Why? One could say, well, environmental conflicts have increased in the country. That is evident because of the numbers that I have provided to you. Because this situation for environmental conflicts has shown the difficulty for um, common law to decide in this matter. Human resources are not enough. Technological, scientific resources are not enough. So we found the Constitutional Court, they asked for concepts to universities, but sometimes we say, this is not enough. It is important to appropriate significantly the country with the second wealth in the world, environmental wealth in the world, but also a country with a lot of environmental conflicts. So this shows us how are we going to assume this with this special jurisdiction. So I think that there are some arguments in favor of environmental jurisdiction, especially because communities know and demand protection of their environmental rights. People know that they have the right to breathe clean air, clean drinking water. They know they have the right to have an adequate landscape. And we see that these communities, they are looking for strategies to overcome environmental conflicts in their territories. So from local scopes, we have these consultations and looking at incidents in legislation, incidents in Congress. Sometimes this is very hard to get there to Congress, or communities are very appropriate. They appropriate and they present actions like popular actions, keeping in mind that people understand that in their mind, they know they have those rights. Second of all, there is a very important challenge, and is to overcome judicial lateness, or let's say past due. What does this mean? This means that there are processes that should take at most a year, but they are past due because they're taking years, 10 years, like Bogota River. Rulings, even if they are very simple, they take 3 years. So this means that taking long in decisions is happening because judges don't have enough elements, or because judges don't know how to do it, or because judges don't have experts. It's not easy to find those experts. So here, we also need to start looking at all these elements. There is a need for greater specialization of servants and judicial employees in environmental issues. We already found in many of graduate studies that we have judges and servants that attend those programs, graduate programs at universities. So that's why it's so important for universities to keep in mind the environmental issues. Of course, environmental challenges posed by the post-conflict. We see territories where armed groups came from. Those territories are full of stakeholders that are interested in illegal mining exploitation. So judges need to be there to solve these types of problems. We have a great difficulty, great deforestation in the Amazon, forest fires in the Amazon, and also we need to protect our natural patrimony. That is an ethical commitment. It's an ethical commitment for us, for our generation, and for future generations as well. there is this need to guarantee access to justice and make it concrete. Environmental justice must be made concrete. We need decentralization of environmental justice from regions, at regions. There is a question here on the second bullet that says, integration of interdisciplinary environmental jurisdiction, challenges that also mean having a SCASU agreement, make it real, access to participation, and the creation for an environmental court or a special court so that we can have legal and we have legal security, so that we have rulings with comprehensive vision, economic, social, technical aspects all included there. So we need to sit down, think about it. This is a call for the government, for all of us to work jointly in solving environmental conflicts in the country through judges who can prepare clear, precise rulings that can be complied with. Thank you so much. Thank you, Gloria, for your presentation. It is a very detailed presentation. I'll pass on the floor to Oscar Dario, professor of Externado University. Thank you so much. Good morning, everybody. I am very pleased to be able to participate in such an important event that closes today after 4 magnificent sessions that have been so useful for our country and a great importance to get to know experiences, see how this topic has worked in other countries, what is advisable for Colombia, where should we focus our design in judicial matters. I would like to thank Miguel Londoño, Angela Maya, Carl Bursch, everyone from GGGI, Environmental Institute, judges from that have supported us in this process, this training process. Well, I take the flag where Gloria Amparo left it. What is convenient for Colombia? That is the question they have asked us. Organizers have asked us, where should Colombia point toward in this topic? This is the environment, climate change, question of the century. I would like to start with Gloria finished, post-conflict. This is something that cannot be separated from the environmental discussion. What to do after signing the peace accord in 2016? The peace accord that has over 25 regulations about environmental issues. Many of them are still not applied. So, post-conflict in Colombia, peace accord, the first chapter related to land, reincorporation, quality of life. This peace accord has over 25 specific points related to the right to healthy environment, ecology, environment, protected areas, food safety. There's so many rules related to the environment that must locate us where Gloria Amparo located us. Our country signed the peace agreement. There was a constitutional framework for that peace agreement or peace accord. Therefore, this must be enforceable. There are 2 articles, 1.115 and 118 articles, the creation of agrarian jurisdiction. What is this related? Why is this related? You must be asking yourselves. It's very related. On many occasions, Colombia has attempted to have these agrarian jurisdictions. So there is a depth with the agrarian problems in the country. This has an environmental components, protected areas, natural resources, access to the natural resources. So this is all linked to agrarian problems. So on the one hand, we need to create this agrarian jurisdiction, like I told you, because of the peace accord. And in the peace accord, we have, I repeat, over 25 regulations. We need to articulate environmental issues to the peace legal framework. On the other hand, we have the environmental problems that was very well summarized by Gloria Amparo. So we have this scenario. We have the agrarian problems and we have environmental problems, which are complex, difficult, that require a decision. Therefore, the question is, this environmental specialty, agrarian specialty is good? Yes, it is good. It is necessary. Why? First of all, there is this need to comply with the peace accord. It is a legal constitutional commitment that imposes creating agrarian jurisdiction. It is even included in the peace accord as one of the conflict resolution mechanisms to guarantee food safety. So on the one hand, we have agrarian jurisdiction and we have this commitment of 10 different attempts since law 200. Then we had another law in 1943, law 4, that also works with land judges. Then in 1957, those issues are given to labor judges. Then in 1964, it goes back to civil judges. In 1973, there was this agrarian room in the state council that never was fulfilled. In 1987, it was not complied either, that law. And then in 1988, there was this agrarian room in the state council. It was not complied with. 1989, there is this agrarian jurisdiction with a little bit of strength. Just a few judges started out. Just some agrarian rooms worked in Antioquia and Cundinamarca, and they were assigned to the Supreme Court. Then 1996, the statutory law for justice administration set out suspending those rulings from agrarian judges to civil judges. Then in 2012, our procedural code, there is this idea of agrarian judges. 10 attempts that I mentioned throughout the past century that we have not been able to comply with. Then we have environmental issues. What are we going to do about environmental issues? We need to have a specialty court. So this is our proposal comes into place. We have been working at the State Council for the past 3 years with Danilo Rojas as president, Mr. Ramirez, Mr. Dula, Bermudez, and this year, the president of State Council, Mr. Armando, they have understood the need of articulating agrarian needs, environmental needs with the reality of the country. Here, I would like to reflect on these last 3 sessions, judges, experts, Judge Benjamin, and other international judges have proposed recommendations. And I would like to bring and talk about the suggestions. We need to look at the reality in the country. What is the reality? Great agrarian conflictivity. We are behind to resolve agrarian problems. We have new environmental conflicts because of all these commitments, all these situations. And recently, the Escazú agreement, as if all that were not enough, we have these complex agrarian problems we have not solved we have not solved the problems for the past 50 years, and then we need to also take into account the social and economic reality in the country. What is the proposal from the State Council? Last year, it was out into public light with the support of controllers office, the ombudsman, international conservation, universities. The proposal of State Council is to produce a fourth important head in institutional matters. The first one, which one was the first one? We're the first country that we had in 1974, we had the code. The first code in Latin America is still in force, that natural resources code. It has helped us in its photographs for many countries. What was the second institutional hit? The Constitution of 1991. That constitution is ecological, let's say 30 or over articles talking about environmental issues, rights, institutions, ecological function, economic model, functions of territorial institutions, control mechanisms, and so on. A third institutional hit was the creation of the Ministry of Environment with all the good and bad things in the ministry. That is the reality. So the invitation to the country, and that's how we formulated from the State Council, is to produce this fourth historical moment, that is the creation of agrarian and environmental specialty in the contentious administrative legislation. It does not mean that common law cannot have that mirror function. I am not to talk about this, but concretely, what the State Council thinks and the project we've been working on, calmly respecting attributions in powers, is that in our opinion, the commitments of the peace accord in terms of agrarian issues, the Escazú Agreement that talks about information participation and access to environmental justice, because of these two reasons and because of all the complexity that was explained by Gloria Amparo, that we want to create environmental agrarian specialty. Let's describe it. What would it be like? Oh, there is a very important exercise. In Colombia, for the foreign judges, in Colombia, well, since 1993, we have had the public ministry. Professor Benjamin says that one of the reasons that strengthens this specialty is the strong public ministry. And in Colombia, we do have it. It is paying attention to communities, technical issues, social, agrarian, environmental issues. So Professor Benjamin mentioned that a very strong public ministry helps the scheme, the justice scheme. Let me summarize our proposal. Because of the peace accord, well, we have PEDET, PDET municipalities. Those municipalities are the ones that were where the crisis was in the conflict. They have these special development plans. So our proposal is to create judges. Burstyn and Wiley, they mentioned it. Judges mentioned this. They need to be close, right? There needs to be closeness. So in those PEDET municipalities, not in 172 municipalities, not in all of them, but creating them those judges. So within administrative courts that already work there, their environmental agrarian rooms need to be created, or green rooms. In our opinion, they should be one in the Caribbean region, Guajira, Magdalena, Bolívar, Atlántico, Sucre, Cesar, and San Andrés y Providencia, all those states. They should work, the legislative body would say where, in which capital, in which state we would have the agrarian and environmental room. The second region, Urabá, we have the states of Antioquia, Córdoba, which are very complex, right? Social complexity. The third one, Pacifico, close to Ecuador, Valle del Cauca, Cauca, Nariño. The fourth one, the coffee region, Caldas, Quindío, Risaralda. the mountain range, the Andean mountain range. The fifth one, Andean region, Huila, Tolima, Cundinamarca, and Boyacá, 4 states. The sixth one, the East region, the border with Venezuela, both Santanderes. And the seventh, Orinoco, Arauca, Meta, Casanare, and Bichada. And the eighth one, a very new idea, Fabio Arjona from International Cooperation, the Amazon region. As the international cooperator, Fabio suggests that this is the moment to have a green court in the Amazon region. Like Professor Benjamin said a week ago, more than 1 million hectares without even having, in the Colombian case, having one administrative court does not make sense. Social conflictivity, environmental, economic conflicts, climate change, they all require for the country so the international cooperation of the country turn their eyes towards the Amazon. So this eighth one would have Amazonas, Caquetá, Guainía, Putumayo, and Baupés, all those states. Okay, and another part of the proposal is to add, we already have 2 rooms, contentious administrative, and we have 4 different judges, and they are the ones who know about environmental issues. So our proposal, since we're gonna have judicial assignment, so in that very first room, we have 2 additional rooms besides those 4. So in general terms, this is our proposal. Why integrating agrarian and environmental issues? In the pandemic, the country and the world will have economic issues. The idea is to create this specialty, let's say rural specialty, because of the judge showed us, you need to look at agrarian, rural, and environmental issues and understand that that specialized judge on administrative matters, it'd be great for that person to have an expertise in environmental, utilities, agrarian rights, and other rights, and then other environmental rooms, the second instance, and the State Council as the closing court. This proposal is practical. We believe it reads reality. Just as in Colombia, we had administrative judges that work today with this law that created them. Well, here we're proposing exactly the same thing. Our idea is to support, as we have done it, support the government to build this proposal, having these environmental agrarian courts, one subsession in the State Council in charge of these topics, so that we can comply with the Escazú Agreement, the Peace Accord, and resolve in a specialized manner environmental and agrarian conflicts. This is a way the state can be strengthened. Thank you so much.
Thank you so much, Mr. Amaya, for such interesting presentation and important contributions. We have received several questions and we don't have much time to answer them all. There are several questions about topics that are very interesting, such as deforestation, glyphosate, but I'm gonna focus on filtering the questions specifically related to the role of the judge, the judicial authority, and the creation of this type of jurisdiction, environmental courts, which is the topic at hand. First question, I'd like to highlight that we have 238 people connected to YouTube, the YouTube live streaming, and we have a very live conversation in the chat. So the first question is addressed to judges, foreign judges, Mary and Anders. The question is about the destination of the fines, the final destination of the money fines or sanctions in your country. I can tell you a research project at External University with External yeah, Trinidad University will find that these sanctions in Colombia being from the administration do not always have the reparation destination to repair the environmental damage, but they remain in the institutional management of corporations, EARs. So in your countries, does that money that you collect from fines and sanctions, what is it used for? What is the destination? Where does the money go?
If I may start, then in Sweden we have different kinds of fines, fines that are imposed by the courts in criminal matters. They goes to the state, and that is also the fact that when it's those environmental sanction fees that I mentioned that the environmental supervisory authorities impose for minor offenses, they are also going to the big hole in Stockholm, we call it, to the state. But we also have some similar sanction fees in the building for offenses on the Planning and Building Act, and those sanction fees goes to the municipality that has imposed them. But otherwise, this goes to the budget in Stockholm and will be then transferred as any other tax that is allocated there. So there is no link towards repairment. The repairment then is we then order the operator to make measurements for repairment, and then he or the company will have to make the measures, and they will have to pay for it themselves.
That is very similar to how it is done in the state of Vermont. And that is why that I put a number of financial instruments into the slide about enforcing court orders, because as well, if you have authority to require that the defendant place money into a fund to be used for the restoration, then, and that fund is supervised by a state authority, then you don't have quite the same problem as you do if it all goes to the central. If criminal fines, for example, must go to the central treasury and they're not earmarked for the restoration.
Thank you. The next question is also for the foreign presenters. Is about the legitimacy, or something that we have called the Stanley, and it's who can access to the justice. I think she said access. I think it's been mentioned, but it's a recurring question. So who can have access? Who has the legitimacy to access these courts? And we've also discussed during some work sessions of the project group that here in Colombia, we recognize the rights of nature, not necessarily we demand it through popular action, action of law, that the person who places the action, who has access to justice, is a victim of the damage. It could be started by or filed by general interest. Do you have any similar figure by which, by virtue of the general public, general audience, anybody can have access to these to start a law? I don't know, an action of law?
Well, with us, it depends entirely on what statute the case is brought under. In our municipal cases, a case can be brought by the municipality, and this covers a great many of our development permitting cases. Case can be brought by someone who is affected, or it can be brought by, and this is an interesting concept, it can be brought by a group of 10 or more people in the municipality. And those people do not have to be, as long as there's a group of 10 or more, it doesn't have to be people who are actually affected. On the state level, you have to be within the scope of protection of the statute you are acting under, but you don't necessarily, I mean, you could be a member of a let's say you fish in the river. You don't have to have suffered pollution. You just have to be using the natural resource or appreciating the natural resource. So it is not that limiting, but because we don't have the constitutional protection to bring a case there, you don't have that that same process by which you access.
Yes, and if I take the example from Sweden, we in administrative cases, a private person that will open a case must be affected personally in one way or another in order to have the interest that is regarded as a requirement. On the other hand, NGOs may open up cases because they have a special position according to the Aarhus Convention that we have mentioned here before, that they have access to justice in a privileged way in environmental matters. But otherwise, we don't have this, what you call actio popularis, that anyone can go to a court in administrative cases, and also in civil cases. In order to have any luck with the outcome, you must have suffered some kind of damage or anything. So we really, I think, but this is developing. We would have today a problem if we got a suit like in Netherlands, the Agenda suit that was where a kind of civil suit against the state in regarding measures for climate to reduce the states, or rather to increase the states' measures to decrease emissions that affects the climate and the greenhouse gases and so on. That was a suit that was made by civil persons, and it was pursued from the district court to the appellate court, and also in the Supreme Court of Netherlands, that in their judgment came to the conclusion that the state has not made enough in order to reduce the effects on the climate.
Thank you very much for your answers. I have one additional question right now for the foreign presenters, and it's if there's any record of people who have been sanctioned because of behavior against the environment, and if you keep that record, and you use it to avoid that they prevent them from conducting future businesses or future commercial activities. For example, a database of people who have committed crimes against the environment. They have been sanctioned because of their behavior against the environment. That prevents them from conducting future businesses.
Well, certainly the Environment Agency, which is the enforcement agency bringing these cases, keeps all of those records. And the only way an organization would be prevented from doing future business is if that were an order imposed in a case. But I think that it would be taken into account if such an organization applied for a new permit to do some operation in another location, then based on the experience with that organization, they might have to put into place more protections in advance of starting work, such as a letter of credit or a fund for cleaning up after the work was done, because if they had been shown not to do it in the previous time.
Yes, we have criminal records, but they are general for all criminal actions where you are convicted in court or by the prosecutor by this summary imposition of a fine. But we don't, but then in these records, of course, you can put a question that you can find out if they have been convicted for environmental crimes or not. But then in order to stop future action, then it's this ban from commercial activity that I mentioned. And that's a special decision by the court. So you need to have that decision, and that is the prosecutor that claims to the court in order to ban from future commercial activities.
Thank you very much. Now I'm gonna move on to questions about the future view for Colombia. First question has to do with, I'm gonna read it. This jurisdiction that you suggest, either agricultural or environmental, would only resolve environmental conflict cases or also criminal cases? And how would it work in case there are crimes related to this question? This is for Mr. Amaya and for Gloria. Go ahead, Gloria. But the truth is, this is something that we have to look into with a lot of caution. What would it mean? Because if it's a creation of a chamber, for example, the state council level, we have some competencies that have to be defined about this jurisdiction. If it's a special jurisdiction, well, we always have the question, yes, either constitutional or legal issues, how to sort out actions of law related to environmental concerns. They would have to deal with that. But I believe it's a proposal that we have not clarified yet. We've witnessed the need to have elements and specialized judges in those areas, but the how and to what extent would it be? It's work to be done. And especially because creating a special jurisdiction would imply a process in addition to changing our constitution, probably the regulation of competences. So that means work, long work. So I think right now we have assessed that we are, it's possible that we're having this debate at the higher courts, from the academia, the prosecutor's office, but how it's going to be done, this is something we have to do together. That's right. As a follow-up, I'd say that we have to be very cautious because we cannot cause an earthquake or a tsunami, uh, judicially speaking, in order to create some specialized spaces. I think here we have to go slowly, step by step, and this is what I mean. One thing is the jurisdiction. A different thing is the competent jurisdiction. The ordinary jurisdiction looks at criminal issues, labor, and civil. That's the Supreme Court is the highest expression of this for decision appeal. There are civil judges that look at agriculture issues. Let's say daily agriculture conflicts. Some of them, of course, with certain environmental component, but the extremes conflict of the ordinary jurisdiction are particular, and we should not lose sight of that. In the case we go to the other tower, I mean, for the same building, but a different tower, ordinary and administrative jurisdiction. The administrative one is the state council. The state council itself, in their administrative jurisdiction, knows, of course, the conflict between public entities or where one of the parties is a public institution or a private party exercising public functions. So for that jurisdiction, again, administratively speaking, the proposal is to create these judges or these green or environmental benches, but with losing or stopping the other ordinary jurisdiction, the judges continue to hear the criminal cases, and if there is a competence there, there are some benches, there are some higher tribunals, and the court, the Supreme Court. So as Gloria put it, with with a lot of caution, because we cannot do what is working well. And the proposal is just a draft is to create some judges, specialized courts, or specialized chambers or benches, and two places in the state council for this agriculture environmental jurisdiction. Thank you for your responses. Here's another question that has to do with the judicial activism. The question is, we can say that the lack of a specialty of environmental jurisdiction has led to have the judicial activism phenomenon in Colombia. This is for Colombian judges, but in case Anders or Meredith want to add something, that's fine. You're welcome to. So how an environmental jurisdiction may unfold in front of what we call judicial activism. Could we say, again, that the lack of environmental jurisdiction has led to see this judicial activism in Colombia? I'd like to start. The lack of a jurisdiction, well, I think there are two things that are very important. First, all the program, the advance of the Constitution, environmental rights in the Constitution, the creation of the Ministry of Environment, everything that's got to do with this appropriacy, ownership, the people, communities around their rights after knowing this new Constitution. And very specifically, I believe that when the Constitution begins to talk about, so importantly, about the environmental decisions and that they should have the participation of the communities, that has caused people to be empowered. But activism has taken place precisely because of the generation of conflicts, because of the issues we find. People know their rights. They know there are some environmental rights. They know, for example, what actions can be taken regarding this, and they go to the judges because they are environmental conflicts, because they have difficulties with their natural resources, because others take or grab their natural resources, because others pollute the waters that they can have their daily living. So this causes that they go to the judges to sort out these conflicts. Ideally, we should prevent conflict, but since that doesn't happen, then people have to go to judges. Exactly. I would add Gloria's comment, that there's a claim, a very strong social claim or request, in spite of having environmental institutions. There's a Ministry of Environment, there's a system of corporations, the CARs especially for foreigners. CARs are not part of the municipality, but nor the country. They have a little bit of everything. The regional autonomous corporations are public entities, yes. They are in the regions, but the board of directors is appointed by one member of the President of the Republic, the ministers, institutes of study, the governor presides that CAR, the ethnic and Afro-Colombian communities, NGOs form the CARs, and they have an autonomous system. In speaking of their own governance, they have their own appointment system and their own resources. That's how it worked in Colombia. And there have been exceptions, but most of the cases, the system, I'm not talking about the people, but the system in Colombia works relatively well. Of course, I'm not defending or saying that they are perfect or free of guilt, but it's worked. What is the difficulty, in my opinion, of this activism? I respect it, of course, and it's that people do not have a way to claim that state to defend their natural resources is weak. The CARs are weak. For example, the Amazon is unbelievable in Colombia. The director of Corpo Amazon, I don't know who he is, but I think it's a national character because he has to be in charge more than 27 national territory, just one single person to deal with the Amazon for 6, 7 departments. It's impossible. For example, deforestation, to deal with deforestation, illegal mining, climate change. So the administrative redesign of the state causes that people do not find in the supposed administrator, the CAR, to find a response from them. A weak state, a weak executive causes the reaction of the community, of course, in the judicial branch, and then from then, of course, the decisions that are made. Well, thank you very much. Along the same line, well, here in our country, we do not have an environmental jurisdiction. We have a question is what adjustments should be implemented or are being implemented? Do you know that are being implemented or can be implemented so that the environmental decisions and judicial decisions are adjusted or correspond environmental reality? Here we have discussion how to do this, in other words. So what would be the recommendations? What do you know of that is being implemented so that the environmental decisions and judicial decisions, environmental concerns are corresponding to reality? Well, let's start. I believe they are important things here. This that we're doing now, I think this is key. What we're doing now, it helps a lot. Training to judges, for example, something we're doing in environmental concerns, that's key. I believe that it gives them many elements. So the issue of judges is the judge who's there in the Amazon. It's good to be able to train those judges about environmental concerns because they'll be hearing these conflicts. So I believe these are big opportunities with the training for judges. Second, I think there are key elements, and it's from the academia. The academia may contribute with very important elements from research to be able to offer mechanisms to judges so that they can use them for decision-making purposes. And I believe there are processes that are very interesting. For example, what we saw at the Constitutional Court level, the friends, the support from experts to for decision making, it's also relevant. And this task of arriving at environmental justice, it's a task for all of us. We all have shared responsibility, even each one of us as individual, to be able to contribute to environmental protection. Let's support to provide judges from anywhere, the support to judges. When I was in the academia, I received many requests from, especially from the Constitutional Court. about support on topics that were very complex, and we studied them, we analyzed them. But there's also the need, for example, technical issues of support from research institutions. I think a lot can be done there too. The broadcast, research, outreach, training to judges, this can all may help pave the way to our goal. So it's as for everyone. That's right. It's to educate, and educate. In this case, exercises such as this, we thank this as a country, the empowerment of the communities, and for them, for the communities to know the environmental variable. There is there's a lot of wisdom there. We are a country that has over uh, regulation. It's better to have a constitution than not having it. It's better to have a code of natural resources than not having it. So I believe and I agree with Gloria Amparo. We must strengthen the research institutions. We also see the presence of the institutes, and in many cases they've been forgotten by judges themselves. Research institutions in Colombia are spread by zones. Belmont for the Caribbean, IAP for the Pacific, Sinchi for the Amazon, Humboldt for the Indian region. So I believe that it is necessary. And of course, I don't want to add one more standard as we needed it, but it'd be nice if the council of the board of directors of the CARs took advantage of the research institutes, and as it's happening in Chile and it's being shared by the international presenters, that scientific knowledge that is a complement to the legal knowledge can be given, as it happens in Chile, with magistrates, they call it ministers there, but who are not attorneys, or with the technical scientific support, the right one, that is like a justice assistant for judges. But in summary, just training is to believe in democracy, believe in the institutions or judges with the big limitations they have in our country, of course. They've been stressed in every field, not only in the issue of environmental justice. We believe that they could take a qualitative and quantitative leap with this initiative that, of course, it's to be discussed by everyone. Thank you very much. We have just 10 minutes for questions before final closure, and we have several questions about some process-based topics. A question I believe was interesting is for Dr. Amaya or Mr. Amaya. How convenient is to remove the ordinary civil jurisdiction, remove from the agricultural issues when it's about actual rights, for example, the right to property? It's not constitutional. I mean, the agriculture issues, something of the ordinary jurisdiction topics. I mean, conflicts of land conflicts between private parties have been, are, and will always be from the ordinary jurisdiction. And they do not go to the specialty that we are discussing. They don't. Those that go to the specialty under discussion are about contentious. I mean, where the extremes between public entities or a private party exercising public functions or administrative acts of the public institutions with environmental concerns. Whatever management you accept in ordinary jurisdiction, it's competent to hear topics between private parties, between individuals, as is the case of most conflicts, agricultural and land conflicts. Now, those where there is another extreme public institution, for example, or a private party exercising public functions, it's a different context. So, like I said, we cannot bring an earthquake, cause an earthquake in the system. We need to keep separated the competence of the jurisdictions and provide space to these new commitments. Principle 10 of agreement, the Rio Declaration, is fulfilled with environmental justice. And that's what we are suggesting, to strengthen, of course, the jurisdiction, the existing jurisdiction. Thank you. Here's another question. I know this has been discussed at different levels, and what we should, and this is also for Gloria, what do you think if we should have some control mechanisms, some specific actions, some specific processes in environmental concerns? I mean, the tools, the judicial control mechanisms are enough, or should we create more specific ones for this new jurisdiction or proposal? I believe we do have key actions now in environmental concerns. What has happened with popular actions, the popular actions turned more quickly. That's why it's so important to talk about the specialty. One could think, no, we don't need it. But I personally believe that these actions right now are some judges with all the technical elements, all the elements to make decisions very quickly. There we could work with more suitability, more efficiently in environmental concerns. So I had not thought about new scenarios or legal scenarios for this subject, because if the ones we have now work efficiently, I think that would be enough. I think we could achieve the results that we expect for environmental protection. I agree. I believe the current instruments we have in Colombia, the popular actions, constitutional actions, actions of law, and two codes, the General Process Code and Administrative Procedural Code, they're more than enough to serve as it's being done in all the jurisdiction and all the specialties to take care of environmental concerns. Well, thank you very much. And now the very last question on processes, and it's about the times. We know that one of the difficulties in our judicial system, sometimes the decisions take too long. So a question has to do with how we can adapt preventive or interim measures more efficiently, more quickly. So would that be favored within the framework of this environmental jurisdiction? So how about the times of decisions for justice to be more efficient? I would go beyond that. I would look at the need of having preventive strategies. And this means a very important work from the institutions and from everyone. It's unfortunate what some years ago I heard about in a corridor with the Ministry of Environment. And it was clerk saying, I think we should do anything that should be sorted out by a judge in 10 years, within 10 years. I don't think that's right. We need to work on strategies to prevent environmental conflicts. Leave everything up for judges to decide is not the ideal scenario. We should look for other strategies, special strategies, to be able to prevent environmental conflicts that judges are overwhelmed with so many cases, with so many decisions, as stated by a judge. A judge gets such a complex case and says, I don't understand it, I just leave it out, feel, I don't want to look at it, so I delay it. So there's a task to prevent institutions, we ourselves, the work with the communities. Many of the topics that have been the result of legislation are because of participation. Is how to participate. How do we overcome all that, the difficulties? If I participate, you participate, then others decide and they don't even hear me. So how do we sort out? And speaking of the commitments, the system that judges have elements that may allow making measures, an interim measure, for example, that the judge will not be afraid because the measure will not create a big chaos in every sense and in the country, and we'll have the strategic elements that we can overcome this difficulty where we are. I'd like to add that as soon as we have to keep in mind the principle of precaution and prevention. Many times we find in the courses by the state council and when they are present, there's a lot of confusion there. We need to bring clarity to the interim measures that are adopted in the exercise of the precaution principle. In case of doubt, while it's sorted out, let's suspend it. When we overcome the doubt, when we have certainty to if there is pollution, of course, we keep it, but there's no pollution, there's no impact. The judge himself, who had the strength and the quality to impose a measure, must have the power to release it. That's the application of the next stage, prevention. That's why I like to close with this argument. This about environmental jurisdiction in Colombia. The specialty has been supported by Rustela, the deputy minister, and by several ministers, the Council of Judicature, and recently the prosecutor Carrillo, who has clearly understood to bring together the environmental and agricultural concerns. In these cases, environmental and agricultural concerns, the first precaution principle in case of doubt, then seek, research, investigate. Once the doubt has been clarified, the next step is clear, either to ratify the interim measure or to relieve it. This application of the principle of precaution. Okay, thank you very much, everyone. So we close the QA session today. And during this fourth training session, I'd like to thank all the presenters for today's session. More and more questions arise. The chats are filled with more and more questions from participants. But we can summarize, and we can summarize this as a clear message that we need to build and we need to discuss this further in our country. We have a question here from Magistrate Sandra Gonzalez, a recommendation from the Higher Council of the Judicature, where she says that it's important to recap on key aspects to keep in mind. And together with the project team, will we be gathering the memoirs for the project within July and probably August, and we'll be sharing them later during August again. So thank you very much, everyone. I pass on the floor to close to Carolina Jaramillo, country representative from GGI. Carolina, you have the floor.
Gracias, Ángela, y un gusto saludarlos a todos, doctora Maya, la doctora Gloria Amparo, a los jueces Meredith y Anders. Aquí los he estado escuchando con mucha atención y disfrutando sin ser experta ni mucho menos, pero es fascinante escucharlos hablar de estos temas. Para nosotros es un gusto como Instituto Global para el Crecimiento Verde apoyar este esfuerzo y agradecer inicialmente a la Procuraduría General de la Nación y al Environmental Law Institute por promover y facilitar este proceso, resaltar que para nosotros y para Eli es un gusto poder responder al interés y la demanda que ha habido en generar estos insumos técnicos para cualificar el debate sobre jurisdicciones ambientales en otros países y las lecciones aprendidas en otras latitudes que puedan ser de utilidad para este debate en Colombia. Entiendo que se han compartido a lo largo de estas 4 sesiones de trabajo, experiencias y modalidades de jurisdicciones ambientales de los jueces en Suecia, Vermont, Estados Unidos, en Hawái, así como algunas experiencias de América Latina que han sido muy inspiradoras, y espero que todos esos insumos nos ayuden a reflexionar y seguir construyendo este debate con mayor profundidad y ver qué es lo más conveniente para el país. Asimismo, pues entiendo que como parte de este debate de la reforma a la justicia se tendrá que sopesar los esfuerzos de reforma constitucional y de asignación fiscal asociados a una jurisdicción ambiental específica que responderían a las necesidades del sistema judicial para hacer efectiva la solución de los conflictos ambientales que hoy bien expusieron quienes hablaron previamente, y así como la judicialización del crimen ambiental. Particularmente para nosotros es de mucho interés el tema de la deforestación y sopesarlo frente a otras opciones como nos contaba el doctor Amaya, como una especialidad agraria o ambiental en el marco de la institución.
Sorry, Carolina?
I'm sorry.
Yes?
Carolina?
Sorry. I think you're on the English channel, so people are not hearing you in the Spanish channel.
Bueno, eso sí está difícil porque no sé cómo pasar
I don't know how to move
al
on
otro.
to the other channel.
If at the bottom there should be something that says interpretation, or it says English. If you click on that, you can click to the Spanish channel.
Can you hear me? Should it start again?
Probably would be good.
All right, great. I was just told that I was not in the Spanish channel. I was in the English channel. I apologize for that. But once again, I want to thank everyone, the judges and magistrates who have joined us today. I was just saying that to us as GGI, it's a great pleasure to be able to contribute to these experience exchange at the international level, especially on environmental jurisdiction, to hold this debate in Colombia, to help feed that debate in Colombia about that model. And precisely, it'll be a great pleasure to continue to support everyone through our program with ELI to support judge training in these areas. I understand that throughout these 4 sessions, you've shared interesting experiences from the US, Sweden. Today, we have Mary Sanders present today. I heard them. I know there have been other Latin American experiences, very interesting. And in the end, we hope that with these insights, the debate on the best reform or addition to the current institutions to be able to resolve environmental conflicts in Colombia and judicialize environmental crimes may be suitable, especially to us as DGI. We've been helping, cooperating with the national government in other aspects that are necessary to control this overwhelming phenomenon of deforestation. And we support the government in promoting forest conservation. We start productive green projects, support forest and carbon monitoring. Mr. Maya talked about the management of CARs. We've signed an agreement with CAR in the Amazon to provide them with more technical capabilities in planning forest use and other areas. But all these efforts may be somehow useless unless we actually contain a lot of the conflict and the environmental crimes related to the change in land use. So from that viewpoint, we hope we can continue to cooperate actively in this legal training progress and program together with ELI, and then give important contributions to the debate. So I want to thank Carl, the colleagues, everyone, Angela Maria, for this opportunity, this program. Of course, Miguel Londoño, my colleague, who's been participating actively in these meetings. Thank you very much, Carolina. And to close, I'll pass on the floor to Carl. He's the Director of National Programs at ELI. Go ahead.
Gracias. And good day, everyone. We met at the first session, and I am pleased to see many of you again today. I would like to thank the Procuraduría General de la Nación for allowing us the space to present these webinars. We are delighted for this opportunity, and we were delighted when the office approached us to share our experiences. We have greatly enjoyed working with the Procuraduría to convene these sessions. I would also like to thank our esteemed speakers, and particularly retired Judge Bankston and retired Judge Wright. The two of them were instrumental in conceptualizing and organizing these 4 webinars. I'd also like to thank Judge Crabtree, Judge Hernandez, Magistrate Benjamin, Judge Hankey, Magistrate Amparo Rodriguez, and Magistrate Amaya. We're very grateful to the Swedish Postcode Foundation for their support, which has made this webinar series possible. And I'm personally grateful to the Global Green Growth Institute and Miguel Londoño for their support in these webinars and in the broader partnership. And a final thank you to Angela, who has been outstanding and a gracious moderator throughout the series. We've been impressed by the hundreds of people from diverse Colombian institutions who have engaged in this webinar. It's clear from your comments and your questions, both today and in the previous 3 weeks, as well as in the remarks by Magistrate Amparo Rodriguez and Magistrate Amaya, that the issue of environmental courts and benches is very important to Colombia, and that this discussion is timely. There are many environmental conflicts, and these are increasing. And as the magistrates noted, peacefully resolving these environmental conflicts is important not only for the environmental rule of law in Colombia, but also for peace. We hope that these 4 sessions have given you some ideas of experiences from other environmental jurisdictions around the world, what might work, what might not work. We also hope that it's given you some ideas that you can take forward in Colombia. As you continue this discussion, I would encourage you to think about 2 points. First of all, the decision regarding whether to establish an environmental court or bench, what its scope should be, its relationship to other enforcement mechanisms in courts, and how it operates. This decision is Colombia's decision. And second, we are here to help you. We're happy to share experiences, share insights, but it's really to help you think through what makes sense in the context of Colombia. ELI, GGGI, and our other partners will continue our work to fight illegal deforestation in Colombia. With the support of the Swedish Postcode Foundation, for example, we are working with the Consejo Superior de la Judicatura to train trial courts and appellate court judges and magistrates on hearing and deciding cases related to illegal deforestation. And as was previously mentioned, we have launched a website, deforestacionyderecho.co. This website will include the PowerPoint presentations, links to the recordings for these sessions and to other resources. We hope that you will visit the site and continue to engage with us on these and other important environmental topics in Colombia. With that, I'd like to thank you for your attention and thank you for all your energy. You guys are doing incredible work, and I am very honored and humbled to be able to assist in the process. Good day.
Thank you very much again, and have a great day.